Hello, my name is Michael Tesoro and I prepared this case note on the recent case of ASIC and Colonial First State Investments. Bit of background about myself. I'm a competition and consumer lawyer who run my own practice, Tesoro Legal Consulting, and I've been doing that for about 13 years. So I'm not an ASIC expert, I'm more an ACCC expert, but I found this case very interesting and I thought it deserved some comment. My previous role was at the ACCC as a Director of Enforcement. I had a range of roles there, but that was the last role I had there. And so I'll be discussing this case from that perspective of being a former regulator myself. Now, the outline of the presentation is effectively set out the background, discuss the facts, discuss the decision, in this case by Justice Murphy of the Federal Court, and then some commentary about some of the unusual aspects about this case. And I just find it quite strange, the approach which a number of parties took to the conduct of this matter. Now, the background to the case is the MySuper reforms, which were introduced following a review of the Australian superannuation system by an expert panel appointed by the Commonwealth Government. And it made three primary findings. The first, an unremarkable finding that many members of superannuation funds were not engaged with the superannuation. I think we all knew that. But secondly, that superannuation fund trustees were not always focused on maximising the retirement incomes of their members in an efficient and cost-effective way. And finally, that the members who invested in the default investment option of their current fund were not adequately protected. So there are three main findings, and it resulted in some other recommendations. And the key recommendation was the creation of a simple, cost-effective superannuation product intended to better serve the members whose interests weren't being looked after. And that was to be called the MySuper Fund. And it was only the MySuper product which would be eligible to be nominated as a employer compulsory superannuation fund. And then legislation was brought in between September 2012 and January 2014 to give effect to these various recommendations. Now, the two changes that are relevant to this particular case was firstly the enactment of Section 29 WA of the Superannuation Investment Supervision Act, or the SIS Act, which effectively said that licensees of regulated superannuation funds had to treat any superannuation contributions that they received in the absence of an investment direction as a contribution to a MySuper product. Okay, so they basically, if they didn't have an investment direction, the money had to be put into a MySuper fund product. And secondly, that trustees were required, no later by the 1st July 2017, to attribute to a MySuper fund product the accrued default amount for the member unless they had an investment direction. So that was the requirement that Colonial had to meet to basically transfer these accrued default amounts to a MySuper product before 1st of July 2017. Now, what had occurred was Colonial discovered, and I'm not too sure how it didn't know this previously, but discovered that it had failed to comply with the SIS Act requirements in terms of putting funds in a MySuper product if it did not have an investment direction. So what it sought to do was to design and implement a communications campaign which consisted of letters to 13,000 members and phone calls of the first choice personal super product to get the investment decision or direction effectively to cover up the earlier breach that they'd of the SIS Act, which they'd conducted or committed. So you've effectively got an attempt by Colonial to cover up a breach of one bit of legislation by engaging in a campaign to mislead consumers in breach of other legislation. Now, in the calls and letters which Colonial made to its customers, it did not disclose to the members that it was in breach of the SIS Act, and also misrepresented to the members the nature of that particular obligation. and further misled the members in a manner which was designed to maximise the prospects of getting an investment decision. So there were the admissions which admissions which Colonial made to ASIC. Now, I think it's important to note one unusual aspect of this particular case, which is when Colonial were preparing the letter and script that it was going to use to communicate to the various members, it sent a copy of those documents to APRA for its comment. And the first version it sent through in March 2014, it didn't receive a response, but it resent the documents to APRA in April 2014 and received some comments back, some changes. So the letter, which Colonial subsequently admitted was a misleading letter and a misleading script, had been provided to one of the two financial regulators and given the sign-off. So that's a very unusual situation that arose in this case. Now, looking at the decision, as I said before, Colonial was trying to cover up one breach of an act by committing another breach of the act, and ASIC made a number of submissions to the court that basically Colonial was seeking to take advantage of its members of the First Choice Personal Super Fund. Importantly, it's a fiduciary relationship. The Colonial is a trustee of the fund, and accordingly, it's a very high onus. Now, the big issue also was that Colonial denied that it was a deliberate and considered attempt to further its own commercial interests. So it drew a distinction between a deliberate and considered attempt to do something illegal versus taking advantage of effectively the people it had a fiduciary relationship with. And the other submissions that were made, that the conduct involved employees in senior positions at Colonial, affected 13,000 members, caused estimated losses of between 112 to 120 million, and Colonial is a very large corporation. So these were all submissions made that were accepted by the court. And it was also accepted by the court that the representations were made to those members as part of a concerted campaign that went on for 2 years, that the relevant letters and call script had been signed off by Colonial senior management, and there the points made that not only was it misleading, but there was a fiduciary relationship in place. And then during the submissions in court, the key issue is that a settlement had been agreed. ASIC and Colonial had agreed on a range of submissions to be made, and also an agreed penalty of $20 million. So really, you can't support a $20 million penalty if the conduct is described as being deliberate and considered or intentional or willful. So there was silence on that particular issue. And then in the hearing, ASIC sought to submit to the court that the conduct of Colonial was actually part of deliberate and considered attempt to further its own interests. It argued that it was a deception of the members to maximise Colonial getting an investment decision, which would enable it to retain the members in the higher fee first choice personal super product. So it's trying to effectively trick members to stay in a first choice personal super product, which would have generated Colonial much higher fees. So that's the submissions which ASIC made to the court, and Colonial's complaint to the court was that these submissions were effectively made for the first time in the court and were not part of the previous agreed settlement. So the court looked at all the relevant facts and submissions and concluded that it was unable to conclude, or Justice Murphy was unable to conclude, that the conduct was deliberate or reckless. And that's because there was no evidence really of that point. Rather, what ASIC had sought to do was to make submissions on the point without any specific evidence. Furthermore, Justice Murphy said that he would not make any findings about the state of mind of the officers of Colonial in terms of their knowledge of the falsity of the representations or objective recklessness, again because there was no evidence of those particular points. However, he did conclude that the contravening conduct did give rise to substantial losses, $112 to $200 million, and furthermore that if one extrapolated all the calls out and all the letters out and worked out the level of fees that these members had been charged, that the number of offences would have resulted in a maximum fine of $22.068 billion. So a very large penalty. Now, another element in the decision is to look at the financial strength of the contraveners, and clearly Colonial size and financial resources are relevant, and he found that in relevant years Colonial had revenues exceeding $1 billion and net profit in terms of in excess of 200 million. And obviously Colonial was owned by the CBA, which in the relevant years had total revenues of 22 billion and profit exceeding 8.6 billion. So you've got to look at the size of the contravener when seeking to set a penalty. Now, this is the decision that the court made, that he was satisfied that a penalty of $20 million was just and appropriate given the totality of the contravening conduct and how serious it was, including the number of breaches, the period over which it occurred, it involved senior management, it was a breach of fiduciary duties, it resulted in substantial losses, and there was a need for specific deterrence. And there was a big remediation program. So Colonial is repaying the members the money which it improperly charged them. So it's giving back the members the money which you should never have charged them in the first place. So the conclusion was that a penalty of $20 million was substantial and that it was sufficiently high to deter repetition of the conduct by Colonial and others tempted to contravene the ASIC Act. And then the judge gave Colonial credit for the remediation. So they get credit for the penalty because they're returning money to people who should never have paid in the first place. And then he concludes that, the court concludes that Colonial contravened the laws by making false and misleading representation in letters and phone calls to first choice fund members, that there was a recent legislative change with Colonial stated it needed to contact members about, which was not true, that also members had to take urgent action so that Colonial could continue to receive the members' superannuation contributions, which again was false, and a recent legislative change required it to hold investment direction for members, which was not true either. It occurred many years before. So just some commentary on this. I just find this case bordering on the ridiculous. Here you have ASIC with a pretty good case, I'd say from my days at the ACCC, this would be a pretty well a laid Amazare type case. For some reason, it decides to settle the case for $20 million. And it also agrees not to make submissions that the conduct was part of a concerted campaign and willful and intentional, despite the evidence which it could have clearly put on to support that position. So why is ASIC seeking to settle cases for peanuts? It doesn't make sense to me. Then APRA's getting this letter from this Colonial, and doesn't it stop and ask itself the question as to what is this letter all about? What is Colonial seeking to achieve by sending this letter to the members? Surely APRA must have realised that the letter was misleading and it was being sent out to members to hide a breach of the SIS Act. So again, ASIC and APRA haven't really covered themselves in glory. But the most remarkable part of this case is the conclusions by Justice Murphy that a $20 million penalty isn't going to achieve any specific or general deterrence. Like here you have a situation where the company has levied $120 million in fees inappropriately. It's paid $70 million back. It's got a revenue of $1 billion. It's got profits of 200 million. And the judge can say with a straight face, not once but twice in the judgment, that this penalty will achieve any deterrence whatsoever. It simply won't. And when courts are faced with submissions of this nature, they should take a leaf out of Justice Foster's decision in the Volkswagen case and simply reject the settlement and impose a bigger penalty. And I think this is just a great opportunity for ASIC to achieve a very large penalty and achieve some specific general deterrence which went by the by. It's almost like ASIC realised at the hearing stage that they stuffed it up and quickly tried to make some submissions on penalty without the evidentiary basis. So again, that's not going to work out. So just all in all, it's just a really remarkable case. It just suggests to me a high level of ineptitude. I guess it's a legacy case of the previous ASIC administration, so we can only hope the new chair and deputy chair of ASIC will take a much more sensible approach when they're faced with cases of this nature and not really sell them totally short. So that's all I had. Hopefully that's been helpful. If you have any questions, feel free to give us a buzz, drop us an email. Bye-bye.